Good morning. This is Judge Elisa Perez presiding over the 210th District Court Civil Docket for January 31st, 2024. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. We are also streaming all matters live via YouTube for public viewing. Mr. Monares, if you would please call our first case.
Calling case number 2021 DCV 1635. Announcement of counsel, please.
Good morning, Your Honor. James Fuel on behalf of the plaintiff.
Good morning, Your Honor. Lisa Hayes for the defendant, and we are the movant on the motion for continuance.
And I did have that. What I did not see, and I reviewed the motion. Actually, Mr. Fuel, I didn't notice if you had any type of objection to the motion for continuance. I see that you all attempted to mediate unsuccessfully.
I'm not going to object, Your Honor. And I think Ms. Hayes sent over a proposed order this morning, and I don't have any objections to it.
Okay. And so my question was, what kind of turnaround time? It's a little bit of an older case, but I know there's been, I think there was a substitution maybe in 2022, 2023. Let me ask, what's outstanding? What's outstanding? Because honestly, I would like to have this set before the end of the year. So
I'd like for that to be the case as well, Your Honor. Really, I mean, everything's outstanding. We need to finish discovery and do depositions.
Well, thank you for your candor. We'll go ahead and set that for the end of the year. Ms. Hernandez, do we have a good, I'm gonna think December, I don't feel like we've scheduled a whole lot over there. What are you all schedules like? Can you manage a December 6th trial setting?
I could.
Let me just confirm. I think I can, Your Honor. Yes, I'm clear.
So we'll do December 6th. December 4th will be the docket call. There will be another mediation deadline that occurs the Tuesday before the final civil pretrial. Maybe with a little more work, things change, and you can take another shot at that. If you would please complete the court scheduling order with your agreed to mediator, the dates, and we'll get you scheduled accordingly. Any old settings, I can't remember if we have any old settings. I'm not looking at Odyssey, but those will be canceled and we'll enter the new ones. Anything that needs a hearing, just let Ms. Hernandez know along with your pleading and we'll get you set. The continuance is granted. Thank you very much.
Yes, ma'am. Thank you, Your Honor. May we be excused?
May have a good day.
All right.
Let's see, Miss Bali, are you here? Yes, there you are.
Yes.
Okay. All right, let's go to the next one.
Calling cause number 2023 DCV 0997. Announcements, please.
Yes, Carla Valley on behalf of Deutsche Bank.
Is there anyone in the waiting room, Mr. Monares?
Not at this time, Judge.
Miss Bali, I saw that we had this pending from back in, I want to say October of last year, and you all had been working on a few things. Is there, we scheduled it for 90 days out. How are we doing?
It's been on and off hold a couple of times with them working on loan modifications, and it's on hold again with another, I think this is about their 4th loan modification application. So they're trying. So since there is a pending loan modification where we can't get an order on this, can we, I hate to postpone it again, but can we postpone it for 60 days?
What I'll do is a 60-day status hearing.
Okay, perfect.
Status hearing. Okay, we'll reset for 60 days. Thank you very much.
All right, thank you, Your Honor. May I be excused?
You may have a good day.
Thank you, you too.
All right, next one.
Calling cause number 2022 DCV 0153. Announcements, please.
This is Valley National Bank versus RA Transportation LLC.
Yes, Your Honor. Carlos Miranda for the defendant.
Oh, there you are, Mr. Miranda. I didn't see you.
Hello, Your Honor. Chris Brown for the plaintiff.
Okay, we're scheduled. Good morning. Scheduled for a status conference. How are we doing on this one?
Go ahead, Mr. Brown.
Yes, Your Honor. We reached a settlement agreement and had a payment plan that was set forth in the settlement agreement, and because of that, we postponed the trial to allow the settlement to take place. There were 5 months of payments contemplated under the settlement agreement. There have been 2 months that have been paid, and then there has not been a payment made after that second month. Mr. Miranda has we've conferred on this, and unfortunately, his client has gone dark on him and has gone dark on us, and so we have contemplated entering into an agreed judgment, which would forego any need for a trial. I would like the time to be able to put that together and confer with our clients to make sure that that's agreeable to the court and to the parties.
Okay, do I need to have, I'm trying to think, if it's still pending whether that is going to be the course of action, I don't want to put it too far out if we're not sure that that's going to happen. So I'd like a status conference in 30 days so we know exactly where this is going. And then if you find that that's what you all are going to do, then I'll give you a little bit more of a window, but I just want to keep tabs on this. The last notation I had was that there was some type of settlement payment that was due over time. So I'm going to ask that you all come back in 30 days. Let me tell you this though, Mr. Brown, if that is what you all have agreed to, if you want to shoot the court some type of communication saying we're coming up with the agreed judgment, Judge, I need 45, 60 days, whatever it is. As long as you all are in agreement, let me know and we'll reset you. If I don't hear from you all, then we're going to see you in 3 days. Okay? Ms. Miranda, anything from you?
No, Your Honor, that was exactly accurate representation by Mr. Brown. And I think we'd both like to just wrap this one up. So we'll endeavor to get it resolved by the next status conference with an agreed judgment. Then we move forward.
Sounds good. I'll reset it for status in 30 days. Good luck. Take care.
Thank you, Your Honor.
Thank you, Your Honor. Thank you,
Thank
Mr.
you.
Miranda.
Thank you, Mr. Brown.
All right, let's go to the next one and I'll go ahead and call it. 2023 DCV 2647 Maria Reynolds versus West Carriers LLC et al. May I have announcements, please?
Good morning, Your Honor. Daisy Chaparro here on behalf of the plaintiff and the movement on the motion to withdraw.
Marisa Williams on behalf of West Carriers, Your Honor.
Good morning.
Hey, good morning, Your Honor. Gabriel Perez. I will be subbing in for the plaintiff after Mr. Potter is permitted to withdraw.
Okay, thank you. And actually, I understood this was kind of in the pipeline, but I wanted to see if we were going to have Ms. Reynolds. I understand, Ms. Chaparro, it looks like everything is kind of lined up. So in terms of your withdrawal, that is granted. I do see that we are scheduled now, Mr. Perez and Ms. Ibarra Williams, also for a scheduling status conference. Are you all prepared to work on that today, or do you need a minute? Do we need to come back in 30 days?
We can do the scheduling, Your Honor. Just so Mr. Perez is aware, there is an arbitration agreement between the parties. I had seen the motion to withdraw, so I knew that, wasn't sure what the status was going to be, but that way just, it might be beneficial maybe for Mr. Perez and I to discuss that and then kind of see if we're going to proceed with scheduling or filing our official motion and going that route.
What I would like to do then is reset the scheduling status conference for 30 days. So you all can have a chance to confer. Ms. Chaparro, thank you very much for appearing today. Is that everyone on this case? I don't see
Brett Timmons on behalf of the other defendants, Your Honor.
Okay, Mr. Timmons. All righty. So we'll see you back in 30 days. Did you have anything for the court, Mr. Timmons?
No.
Okay.
This is
All right.
a very early case. We haven't been able to do much on this.
All righty. Thank you very much for your time. Everyone is excused. Good to see you.
Thank you, Your Honor. Good to see you.
Bye-bye.
Bye-bye.
All right. Is Mr. Borshall here?
Good morning, Your Honor. This is Attorney Millet Sarah. I'm appearing on behalf of Mr. Borshaw.
Got it.
He, his wife recently had twins, so he's been out of the office.
Wow. Congratulations.
Thank you.
Okay. Well, that's probably one of the best reasons I've ever heard not to be here. So let's get started. Are we at 10:15 yet?
10:17, yes, Your Honor.
Okay. Calling cause number 2023 DCV 1877 Lara Lena Tristan versus GPI Tex F Inc. DBA Shamali Ford et al. May I have announcements, please?
Millet Farah for the plaintiff, Your Honor.
Your Honor, my name's Bill Minucci, representing defendant Ford Motor Company, and it is Ford's special exceptions that are set for hearing this morning. I only need maybe 5 minutes to present my argument to you on that.
Okay. Who else is here?
Isaac
This is-
Blanco here, Your Honor, on behalf of GPI doing business as Shamali.
Uncle, okay.
And Priyanka Parekh on behalf of Bridgestone.
All righty. All righty, Mr. Minucci, you may proceed.
Thank you, Your Honor. This is it's a personal injury case arising out of a vehicle rollover. So what allegedly happened here is that the plaintiff was driving down I-10, or in a passenger in a car going down I-10. One or more of the tires suffered allegedly a tread separation and then detached from the vehicle. The vehicle then rolled and the plaintiff was injured. So the plaintiff sued a number of different defendants, including my client, Ford Motor Company, which obviously manufactured and designed the vehicle. We have the dealership as a defendant. We have several different tire manufacturers as defendants in the case, great number of defendants. So in a case like this, in a factual scenario like this, as a vehicle manufacturer, there are all kinds of potential claims that can arise from a case like this against a manufacturer. First of all, there could be an allegation that the tire itself is defective, the tire that was on the vehicle. Secondly, it could be that there was some defective design in the vehicle that allowed the failed tire to detach from the vehicle, which allegedly happened here. That's a whole separate type of claim that involves a vehicle defect rather than a tire defect. Another type of claim that we often face in cases like this is that the vehicle was defectively designed in its handling and stability. In other words, the reason it rolled was some sort of defect with how it handled once there was a tire disablement. Finally, there could be an allegation in a case like this that the vehicle was not crashworthy. In other words, when it did roll, that the plaintiff was injured more than she otherwise should have been due to some sort of defect with the crashworthiness of the vehicle, whether it's restraints or airbags or roof, door latch, things like that. The reason that I've set forward special exceptions for hearing is that based on the plaintiff's live pleading, which is the second amended petition, and I can put that on the screen if the court needs to see it, but essentially it doesn't give my client any detail whatsoever which of these 4 types of defect allegations are at issue here. And you can see the problem from my perspective. I mean, a crashworthiness claim involves an entirely different set of experts than a handling stability claim and then a tire defect claim. So I'm sitting here looking at the petition. Essentially what it has is a bunch of sort of generic, non-specific allegations against both the vehicle and the tire. Again, I'm happy to show you examples if you want to look at it. You may be able to just pull it up and see. But all I'm asking for is that the plaintiffs tell us, they had to have a good faith basis to file against Ford. I'm sure they did. But they need to tell us exactly what allegedly is wrong with this vehicle or the tires so that I'm not forced to try to defend every single possible allegation under the sun that can come out of an accident like this. It's just simply a matter of judicial efficiency, of holding down tens of thousands of dollars in cost and expense in hiring experts and litigating this claim. I think we're entitled to know specifically what exactly Ford supposedly did wrong here. The tire defendants are in a bit of a different situation. Obviously, the claims against them are limited to the tire itself. That's pretty easy. But I'm in a different boat because the allegations involve both the vehicle and the tires, and there are any number of potential defects that can come out of that. So I'm requesting that the court order the plaintiffs to replead against Ford with more specificity so that we can know exactly what we allegedly did wrong here and what we need to defend here so we can adequately defend the case. I would add, before I turn it over to plaintiff's counsel, that this has, there's some immediacy to this because we just got served with the first set of discovery from the plaintiffs And I mean, I can read you an example of one of the requests for production. It says, produce all documents related to the design, development, testing, and manufacturing of the vehicle. I mean, the problem, if I don't know what the allegations are, is we're going to be right back in here when we have a discovery dispute and they're asking for every document related to the design of every component in this vehicle. I mean, there has to be more of a specific allegation going forward in order for us to adequately defend this case.
Okay. Is that everything, Mr. Minucci?
Yes, Your Honor.
All right, Mr. Farrow, go ahead.
Your Honor, the defendants in this case filed their special exceptions in July. We have repled our initial complaint in September of this past year. Our complaint is 17 pages long. It's by no means a short complaint that's making broad allegations. We have specifically allegated in our pleadings under heading number 8, starting on page 6, we asserted a strict liability design defect claim. On page number 7, we asserted a strict liability manufacturing defect claim. On page number 8, we asserted marketing defect claims. These are all claims that are specific to Ford that they are aware of and that they can adequately defend. We've also made various other allegations, including general negligence and the res ipsa claim within our pleading. At this point, I'm not sure how much more specificity Ford or counsel would like for us to plead this case. But until we've had sufficient time to conduct discovery so we can address some of these concerns, I feel as if our pleadings put the defendant on notice of the allegations and they have sufficient information in order to defend the claim.
Your Honor, I'm happy to show you. I've actually highlighted the second amended petition, and I'm happy to put that.
I have that in front of me, Mr. Minucci. If you want to direct me to certain things, feel free to do that.
Absolutely. Why don't we turn to page 6 of 17?
Mm-hmm.
That's where we start getting into the actual claims against the defendant.
Right.
So causes of action against Ford Motor Company and many of the other defendants, as you can see. Let's look at the first sentence, strict liability design defect. The Ford EcoSport titanium vehicle and the tires thereon were designed, manufactured, marketed, sold, and placed into the stream of commerce by Ford. And then if you go down to the next paragraph, number 23, at the time the tires on the vehicle, on the Ford EcoSport titanium and the Ford EcoSport titanium vehicle were designed, manufactured, sold, and placed into the stream of commerce by Ford, going down, the same were defective and unreasonably dangerous in their design, marketing, and manufacture. So this is the theme that continues throughout this entire petition. Yes, it's long. There are a lot of defendants, but essentially what they're saying here is that the vehicle and the tires, and this is repeated in every allegation, it's the vehicle and the tires that were on it, were defective and unreasonably dangerous in their design, marketing, and manufacture. How? That's my question. That's the question that's not answered by their pleading. Now, Mr. Farrow's correct. There hasn't been a lot of discovery yet in the case. Although the case has been on file for a while, we just got their first set of discovery, but that sort of reverses the order of how things are supposed to proceed. Before you file a case against a defendant, you're required to have a good faith basis to do so, rather than filing a pleading that essentially encompasses every possible theory under the sun for tires and a vehicle, and then trying to do discovery on all of that to try to come up with something. It's the reverse. He's doing it in the reverse order, and it's at an extreme degree of prejudice to my client, because we can't answer discovery that asks about the design, manufacture, and marketing of everything about this vehicle and everything about this tire. It's patently overbroad. It's millions and millions of documents, none of which will have any relevance to the case, probably, because there is one or two defect theories, either with the tires or the vehicle, that he must have had in mind when he filed the case. And that way I can defend the case. But as this pleading is written right now, it encompasses all of those different potential defects that I mentioned at the beginning of my argument. And it's just, it's going to be massively inefficient, massively expensive, massively unfair to my client and to the dealership as well, I would add, because the same types of allegations, vague allegations, are repeated against the dealership. Unless we get some specificity here. And I think I'm not being unreasonable in asking for the plaintiff to just tell us specifically what you think we did wrong here, so we can defend against it and narrow this case from everything potentially under the sun to what's really relevant here to the plaintiff's claims. No problem defending specific claims from the plaintiff, but we just don't have those under this pleading.
Anything else, Mr. Farah?
The only thing I would like to add, Your Honor, is that this vehicle, my client had only purchased it a month before this incident. And so the expectation from the plaintiff's perspective is that there shouldn't have been anything wrong with this vehicle. Ford Motor Company and Shamali Ford had the best opportunity to inspect it and make sure that it was safe before they put it in the stream of commerce. They failed to do that, and it led to a rollover crash. Now, we've made specific allegations within our pleadings, and we feel as if we should have the opportunity to conduct discovery before we address any other concerns the defendant has raised. Quite frankly, a special exceptions is not proper for this particular concern, and we feel as if we've adequately pled our case and that the defendant is on notice of the causes of action we've alleged, and they have an opportunity to defend him.
Okay.
With all due respect, I disagree with everything you just said.
Let me ask one additional question, not so much in terms of what Mr. Minucci has provided and Mr. Farah, but is this the only, I thought there were multiple special exceptions. Were they not also set for today? I have Bridgestone and both Michelin. I thought I saw both Michelin parties having filed special exceptions. Were those not set today as well?
As far as I'm aware, it's only Fords that were set. I didn't see any other defendants set theirs. And again, as I said, the tire defendants are in a bit of a different position because their allegations obviously relate to the tire. Ford, it's like tire plus many different things. That's the problem I've got.
All right. So I am going to grant Ford Motor Company's special exceptions in order, Mr. Farah, that the plaintiffs replead with respect to defendant Ford. It sounds like you all are already going through some of the discovery requests. So I'm going to give you all 30 days to do that. I did see and review plaintiff's second amended petition. So we are going to come back on a status. Well, it looks like we have a lot of things outstanding. Do we not already have a scheduling order in this case?
I don't think we do, Your Honor.
I don't believe so, Your Honor.
We need to do that as well. So it'll be 30 days on the special exceptions, Ford special exceptions. That will be set also with a scheduling status conference. At that time, we will get a trial date set. Usually I would do a year out. I'm not sure that that'll work here, but please be thinking about that as we approach the scheduling conference. We will reconvene on that in 30 days. If there are any other requests for hearing on any outstanding special exceptions or anything else, please make those requests with Ms. Hernandez now. So if to the extent we can have them at the same time, we'll do that. If not, then we'll just have to schedule something outside of that date. Is there anything else that you all have for the court?
No, Your Honor. Thank you.
Thank you for your time.
Thank you, Your Honor.
May we be excused?
Okay.
Thank you.
Thank you.
Thank you, Your Honor.
All right. We're on page 4 now. Okay. Do we have everybody here on Velocity Investments ending 1848?
Yes, Your Honor. Ben Gutierrez on behalf of the plaintiff.
And Trenton Sims on behalf of the defendant, Your Honor.
All righty, calling cause number 2023 DCV 1848 Velocity Investments LLC versus Felix Cash Lopez. May I have announcements, please?
Benjamin Joseph Gutierrez on behalf of the plaintiff.
And Trenton Sims on behalf of the defendant, Felix Cash Lopez.
It looks like we're here for a status conference and maybe there's a request just for a bench trial setting. Is that what we're doing?
That's my understanding, Your Honor.
Correct, Your Honor.
Miss Hernandez, do we have what I can tell you, gentlemen, is, 60, 90 days out is probably tight because the court schedule is very busy. We can do a couple of things. We can try and schedule you after that. And I'll ask Ms. Hernandez if you can give me a good date. I feel like I'd be more comfortable sending you to the referral court just because of their flexibility in scheduling, if that's all you all need. What is the timetable here?
The referral court would be okay. We've already started negotiations, so it's possible that this case would be settled before a trial date anyways. So it's all up to you. All up to you, Your Honor.
And plaintiff's position, Your Honor, would be towards the 90 or greater in terms of to piggyback on my co-counsel or opposition counsel in terms of negotiation potential to allow the parties to be able to do that. I think a little bit more time would be helpful. So at least 90 days.
Okay, I'm happy to reset you all for a scheduling status conference in 90 days. Understand if at that point, what you're really looking at is a bench trial. Maybe our calendar looks better, so we're not talking about referral court, but if we are looking at a bench trial, I may just refer you all to one of the referral judges, okay?
Sounds good, Your Honor.
All righty,
Thank you.
90 days. Thank you very much.
Thank you, Your Honor.
Y'all are excused. All right, Mr. Perez and Ms. De La Garza. All right. Calling cause number 2021 DCV 3473, Yahaira Vasquez and versus Gabriel Reese. May I have announcements, please?
Good morning, Your Honor. Gabriel Bettis on behalf of the plaintiff.
Good morning, Judge Peyton De La Garza on behalf of the defendant.
Okay, so I have some bad news. We were so good at scheduling and working with everybody's schedule, getting trial dates, and we had this fancy plan to go outside of the court's comfort zone and do a midweek jury trial. And lo and behold, I have some scheduling difficulties with that. So I because I know we have all, like, for different reasons been resetting and doing things, I'm going to have to reset your trial setting for February 13th. Because I don't want to have those problems anymore, I am inclined to send you to the referral court. Because if I understood, this was about a 2-dayer max, and that's why we were trying to fit you in. But I'm just not comfortable being able to do something so quickly because I know you all are ready. And I think the referral court could probably accommodate you with much more certainty. So that's what I'm going to do. Know that the February 13th setting is gone. Is there anything, has there been any movement? Are you not at a trial? No?
No, Judge, we're still in the same position. I mean, the last, I know I haven't met Peyton personally, but I know the previous counsel and I had talked and he had come up a little bit, but, we're still, pretty far. So we're ready for trial.
The two referral, sorry, Ms. De La Garza, go ahead.
I was just confirming exactly what plaintiff's counsel said.
So the two referral judges are judges Alcala and Burrell. And so please check in with Ms. Hernandez with I'm not sure who the court coordinator is. Once we get the referral order over to them, I know they also have some transition there, that we have you with someone who can get you scheduled with certainty. Okay.
Okay.
My apologies for that. I will, Myrna, we need to make sure and have the referral order today. And if you all have any issues with scheduling, even though it's referred over there, feel free to contact us. So if things don't get moving quickly, we can help you all with that. Okay.
Thank you, Judge.
Thank you for your time.
Thank you.
You may have a good day.
Thank you.
All right. We'll go to the next one. Calling 2023 DCV 1438 Gabriel A. Martinez versus Dow Tile LLC et al. May I have announcements, please?
Good morning, Your Honor. Brittany Lopez on behalf of the plaintiff.
Good morning.
And good morning, Your Honor. James Fuel on behalf of the defendants.
Good morning again. We are scheduled, well, we're set for a scheduling status conference, which means to me usually a trial date. Is that what you all are looking for?
I think that would be appropriate, Your Honor.
Okay, we can do a year out. Is that good?
That was exactly what I was going to suggest, is sometime probably next year.
Okay. So, of course, I don't have my 2025 calendar in front of me, but I do have my phone. So let's look at a date. We're looking at January 2025. Wow. Okay, this is the first one going into 2025 that I know of. We're going to do January, we're going to go post MLK. So we're talking January 24th, 2025. Is that right? That's the right calendar. Your docket call will be January 22nd. Unless you all know of some conflicts this far out, I would kind of applaud you for knowing that.
I'm not looking yet, Judge.
Okay, well, let's tag your it for January 24th and 22nd. We'll get you the scheduling order. Please agree to a mediator included on your scheduling order. Your deadline will be the day before the final civil pretrial. Anything outside of those dates, of course, just request your hearing with the court coordinator, okay?
Thank you, Your Honor.
Thank you for your time.
Thank you. Take care.
You too. Bye-bye. All right, next one, Ms. Labinati, Mr. J.
Yes, Judge, good morning.
Good morning. Calling cause number 2023 DCV 4531, Anthony Garcia versus Geico County Mutual Insurance. May I have announcements, please?
Good morning, Your Honor. Daniela Labinati for the plaintiff.
Good morning, Your Honor. Ms. Labinati, JLJ for defendant Geico County Mutual Insurance Company.
So you might have heard the previous hearing. If you need a trial date a year out, or what are we doing? Do you have something different for me?
Yes, Judge. In fact, JLJ and I were talking on the phone this morning. It very likely we will probably settle this case in the next 30 days. So hopefully this will be off your docket. If you want to set a trial setting, I guess we could a year from now. But
don't. How about I reset the scheduling status conference for 60 days?
That's even better, Judge. That's
I
good.
think that's brilliant. And Ms. Labinati, don't curse us by saying things like that.
Oh, okay. I don't want to jinx it. But JLJ and I work well together. Believe it or not, Judge, you will never see JLJ and I fighting or arguing.
No, see, now I think you jinxed it right there. Now I think this might work out. But in the next 60 days, if people all are at each other, I'm going to be like, Daniela, you remember you said?
Yes, Judge.
January 31st.
And never to her face, Your Honor. As soon as I hang up, though, I go bat crazy.
Oh, come on.
All right. So we'll reset this for 60 days and see how y'all go. Okay.
Thank you, Your Honor. May we be excused?
Thank you for your time. Have a good day.
Judge, I believe I have another hearing in 2023 DCV 3903. I believe I'm the plaintiff intervener. I know it's not, it's Mr. Glasheen's. I think their office filed it, but I am one of the plaintiffs, so
and this
wait.
It looks like the motion to compel was canceled.
Oh, okay then.
Okay.
Nobody, okay,
nobody told you? What?
No, or maybe it's somewhere in one of my 1 million emails. I think I'm like at 600 behind. So yeah, it's a full-time job just to read emails, Judge.
Have a good day. Good to see you.
Thank you, Judge. Good to see you. Bye-bye.
Bye-bye. All righty. The next one, calling cause number 2023 DCV 1655, Texas Tech Health Sciences Center versus James Edward Sumners. May I have announcements?
Good morning, Your Honor. This is McCool Kelker for defendant, Mr. Sumners.
Good morning.
And good morning, Judge. I'm Samantha Tracy representing the plaintiff.
And we are also here for a status scheduling conference. Do you all need a trial date?
You know, we were just talking, Your Honor, and we also saw the January 2025 trial date, and we're like, let's just be a little more ambitious if possible. And so we're looking for
that.
February 2025, if at all possible.
Oh, that's ambitious. I thought you were going to tell me shorter, and I was going to be very surprised.
Only about how daring we want to be in asking you for a trial date. That's
Fine. That's fine. It's a 2023 case. Did you all have a date in mind?
So I just I'm literally filing an agreed motion on another case for early February. So if we can get at the end of the month, that would, keep my heartburn down.
So February 28th, Ms. Tracy?
Yep, that should work for us.
Okay, so this is how we do it. So we'll have our February 28th trial date. 26 is the docket call. You're looking at the 29th of January being the final civil pretrial, which will make your mediation deadline January 28th. So we are going to send you the court scheduling order, fill it out. Sometimes folks generate one based on what I send you, that's fine too. What I will just ask is have everything on there, including the agreed mediator. You return it to the court within 2 weeks. You're going to have a setting that's going to be like a 3 o'clock setting on a Wednesday for entry of that scheduling order. As long as the court receives it signed by you all don't need to appear. Okay. After that, whatever settings we have, if you need a hearing outside of those settings, then please request them with the court coordinator with your pleading, and we'll get you set.
Okay, and Judge, I'm so sorry. I was writing down at the same time that if the February 28th, 25 trial date, which is that Friday, do we pick a jury on that date, or do we? Okay, and then everybody will come back
on Monday.
That Monday. Okay, and then you said there'd be a pretrial on that Wednesday on the 26th.
The 26th is the docket call, so February 26th is the docket call.
Okay.
And then if you back up, the final civil pretrial is January 29th. The mediation deadline is always the date before that final civil pretrial.
Okay, and is that a docket call in person, Your Honor?
No, we do it via Zoom. We can do it in person, and in fact, we can do anything you want in person. Just let me know ahead of time. If it really looks like we're going and it's something that's document intensive, we'll talk before then, but generally then, yeah, we'll otherwise it's on Zoom. Okay.
Very good.
All right. Anything else?
That's it, Your Honor. May we be excused?
You may. Thank you very much for your time.
Thank you.
Have a good day. All right. The next one is 2023 DCV 1564 JP Morgan Chase versus Jonathan Wagner. May I have announcements?
Mark Doobie for JP Morgan Chase, Your Honor.
Good morning.
Your Honor, Megan DIH for defendant Jonathan Wagner.
All right. This is another scheduling status conference. Do you all need a trial date as well?
Judge, I think we could do it one of two ways. I believe if you could reset another scheduling conference for 90 days out, we may have it resolved by that time. Megan, what do you think? Is that probably the more appropriate way to proceed?
I think either way, I know we can get it resolved within the next 90 days, or I feel very confident about it. I should not jinx it like earlier.
Right.
I know there's all this positive. We'll go with that. 90 days. Well, 90 days we'll reset. Okay. Just know as we reset those things, I mean, I probably was such a far reset. I probably won't reset it again. We'll get you a trial date, or however we got to go forward on something. Okay. So 90 days. Thank you for your time.
Great. Thank you, Your Honor. May we be excused?
Thank you. You all have a good day. Okay.
You too. Bye-bye.
Who's left? Mr. Morales for Mr. Jessup. 3182.
Good morning, Your Honor. I think our case was non-suited early this morning, but I've had it where non-suits don't kick in as fast as they should, and I've been called by the court to appear for a hearing, so I'm here just in case that didn't go through. But I think I'm the last one here.
I signed it this morning. I see it in the canceled, and I signed it this morning. Mr. Morales, thank you for appearing and double checking.
All right, thank you very much, Your Honor.
Have a good day. All right, that should be everything. Correct?
Yes,
all right. Thank you very much.